people to do this type of thing, to ensure that simple things that might seem simple and might seem technical to people here and to people perhaps looking in, but when you're in the throes of something like that, well, it's a whole different situation. It can have profound emotional and psychological effects, and outside of that, resources are tight enough. There has been enough of cutbacks, and if we can redeploy resources in a way that matters to people and that can help the lives of children, as opposed to having HSE officials going in and out of court every week. And I think even the arrangements which the Minister referred to in her speech, whereby the court sitting will be on a specific day of the week, that's something as well in terms of channeling resources properly that has to be welcome. I have no doubt that as Minister Fitzgerald comes to terms with her ministry, and she will have many more pieces of legislation like this that will have a cumulative effect to ensure that children are at the centre of this society in a real meaningful way. I would say this is just incremental progress in the right direction, and I commend the bill to the House.
Thank you. Senator van Turnhout, 6 minutes.
Thank you very much. Minister, you're very welcome as always to the House, and speaking of the children's rights referendum, obviously, as I said here before in the House, I applaud you, I commend you and I congratulate you on delivering the government's promise. And when I was on the referendum trail, and as many of us were, I listened to concerns of many parents in the streets, on the doorsteps, at public meetings, and we can't ignore that some of the no voters were speaking of concerns of how they have been treated or how they perceived they would be treated in the past, currently or in the future. And some was based on reality and some was based on perception. And in addressing these concerns, I stressed the significance of your department's decision to improve the social services system by removing the child welfare and protection from the remit of the HSE and moving it into a dedicated new agency, the Child and Family Support Agency. And I assured parents the new agency will focus on early and accountable intervention that supports better outcomes for children and families, and that will work to keep families together, something that we all want to do where possible. And in July last year, Minister, your department published the report of the Task Force and the Child and Family Support Agency. And on that issue, I've asked the Leader of the House on a number of occasions here if we could debate that. I know the bill will be produced shortly, and I would ask you maybe you could outline for us when it will be produced. But I'm also very cognizant of the fact that there will be 4,000 staff. It has a budget of $545 million. I think many of us could stand up and make an impromptu speech about the failings of the system at the moment, and we all want to get it right. And I believe we should have a debate on the remit, the resources and the vision for the new agency to help frame that bill. And so I would ask you maybe, Minister, to give consideration to having a debate in the House that maybe prior to the publication of the bill, maybe we could inform and join with you, because this is an issue that I actually believe we can have a whole House consensus on, that we all want to work together. But moving to the Childcare Amendment Bill 2013, I wholeheartedly and fully support this bill, Minister, and I welcome the initiative that you've taken and bring it forward. The making of care orders under the Childcare Act 91 are an extremely important function of the District Court in the interest of child welfare and protection. And care orders are made where the District Court, upon the application of the Health Service Executive, is of the opinion that a child has been or is being assaulted, ill-treated, neglected or sexually abused, or where a child's health, development or welfare has been or is being avoidably impaired or neglected, or the child's health, development or welfare is likely to be avoidably impaired or neglected. So a care order allows the child to be placed or maintained in the care of the executive pending the making of a full care order. Ordinarily, the first step, as you said, Minister, in the process is an emergency care order, which can last up to 8 days, followed by an interim care order, which under the present arrangements is only extended by a maximum of 8 days in the absence of parental consent. And we know that in the interest of logic and practicality, District Court judges have until recently, and I believe the beginning of last year, until the recent direction of the President of the District Court, have stopped granting 28-day extensions of interim care orders in cases where the necessary consent has not been provided. And so I really do welcome that the Government has put forward the amendments in order to give the clarity that is necessary, because I believe it was always the intention. They are urgently required, these amendments, to remedy the impractical and counterproductive nature of the maximum 8-day extension without consent in terms of finding and working towards an appropriate solution for children in the cases in question. The current system of returning to court every 8 days to extend an interim care order, especially since extensions, and I've talked to many solicitors working in the area, are practically always granted. So it's not that they're not granted. They're practically always granted. I don't believe it's in the best interest of children and their families. The reality is that it's insecurity for the child who every week knows they're being discussed in court. Every week. You're over one court case and you're into the next court case. An increased burden on parents. The fact that that case is in the public. It is not in the public, but in the district court. But it is there every week, and there's no time given for consideration for working towards a solution. It means also that you have social workers, team leaders, solicitors in court waiting around all day to justify the continuation of the order, only to return 1 week later, again and again and again, for the same case. This seriously undermines the time and resources available to social workers and team leaders that need to be focused on the care and the best interests of the child. I believe it has an excessive and unnecessary cost to HSE and to the court services. I believe it's creating unmanageable court lists at the moment, that there's considerable blockages there. So, for me, I wholeheartedly support the bill. The benefits for me are obviously, I think it will move the focus to the best interest of the child, because we'll be freeing up social workers, most importantly in my opinion the social workers, but other people involved in the HSE towards looking at the best interest of the child. Obviously there will be a significant cost savings. It will mean that the courts will be able to deal with the cases that are necessary to be dealt with. It means that there's certainty and security for a child, that they know that this is what is going to be happening. Because the emergency care orders are there for a reason, but here we're talking about interim care orders. It also, for me, moves the focus to working on to find a solution in the best interest of the child, and it rebalances, I think, the focus from going to court to actually managing a positive outcome in the case. And I think that is where the focus should be. So I do also obviously support you bringing into line the 28 days to 29 days, because it makes sense for having maybe 1 day that you would say that this is the day. And it also ensures there's clarity and consistency, which will greatly benefit the management of court lists. So thank you, Minister. I think it's excellent that you've brought this bill forward. I think there's a lot of people are waiting for this to come through, and hopefully we'll relieve a lot of time. Thank you.
Senator Owen Mullen, you have 6 minutes.
And I would just like to welcome the Minister to the House, and to say, Minister, that I welcome this bill. It's a very sensible change, and I think it's one certainly from my own